the Jet Setting Wealth Advisory Podcast, where your financial journey takes flight with David T.U. As an airline pilot and financial expert, David merges the aviation industry and wealth management to help you navigate today's complex financial skies. Each episode features expert insight, blending personal stories with essential financial strategies. We ask that you fasten your seatbelts and sit back as we prepare for takeoff. Our destination, your financial empowerment.
Hello, everybody. Welcome to the Jet Setting Wealth Advisory, where we help you navigate your financial future with clarity, confidence, and control. I'm David Yu, wealth advisor, tax mitigation strategist, and fellow aviator. Each week, we bring you conversations that are designed to help high-income professionals, business owners, and aviation families build, protect, and preserve their wealth. Today, we're joined by two powerhouse estate planning attorneys and co-founders of Flourish Law Group, Lauren Klein and Kristen and Landon. They specialize in estate planning, trusts, probate, and legacy strategies, helping families protect what they built and ensure their wealth transition with intention, not confusion. We're diving into estate planning myths, tax integration strategies, and the critical steps in high-income professionals, which they see and deal with every day, which they must take to protect their families and their legacies. This is a powerful conversation, so let's get into it. Hello, ladies. Welcome to Jet Setting Wealth Advisory.
Hi, thank you so much, David.
Well, we're all happy for you to be here, both of you. So let's get started. Kristen, first question is for you. When people hear estate planning, they often think it only applies to the wealthy. What does estate planning actually mean, and who really needs it?
Well, thank you. That's such a good question. I think the reality is everybody really needs it. It's so important to make sure that we're kind of planning what happens with, our assets and our estate and our legacy when we're healthy and when everything is going well, because we just never know when we might need to implement that planning, right? So
Sure.
whether, and I think that a lot of people think they don't have an estate, estate planning. We talk to clients all the time and we say, yeah, we want to make sure we plan for your estate. And a lot of clients will sometimes say, well, I don't really have an estate. And then we start listing off what they have. You have your home, you have bank accounts, you have retirement accounts. And I think that really turns on the light bulb for our potential clients and our clients to realize that they have a lot more than they think they do. So yes, it's very important that people that are very wealthy do planning, but for people every day, just like you and I, we want to make sure that we plan for our family members as well, and that we're avoiding the probate process, which is just a messy court system to make sure that your assets get to who you want. So yeah, I think it's important for everybody.
We're going to talk a little bit more about probate and the process and even the cost of it a little bit later on. I've got a few of those questions, and I've been asked that many times with my own wealth management clients. But for now, we'll wait for a little bit. Lauren, from your perspective, especially with your tax background, what is estate planning, or I should say, why is estate planning something that should start earlier than most people?
Yeah, thank you, David. I mean, really to piggyback off of what Kristen was saying, really anyone who's an adult needs an estate plan. And then it kind of evolves with that person as they move through life. So we can think about an 18-year-old who is going off to college. They're now an adult, air quotes.
Sure.
Maybe they want to have a power of attorney and a healthcare surrogate where their parents are named, so the parents can get medical information or make decisions if, God forbid, something happens. We've had clients who their children have gotten into an accident while at school and they can't get information. So starting there, that's like, the kind of first category. Then as you begin to buy a house and have children, but maybe start a business, get a 401k, IRA, brokerage account, all of the things that Kristen was saying comprise that estate, life insurance, all of those things. Then you might want to add to it, but when you think about it from the tax perspective, there's different aspects, right? We have estate tax, which is a very, very niche percentage of our population is worried about estate tax. We live in Florida, so we don't have a state level estate tax. So we're only thinking about federal. Right now, if you're a US person, you can give away or die with 15 million per spouse. So that's a very small percentage of the population versus, when I started practicing, it was much lower. It was in the early millions, the low millions, and it's kind of crept up from there. But a lot of people don't factor in income tax planning too. How do you title your assets? How are people receiving assets? And when we think about legacy and generational wealth, you want to make sure you almost have all of these aspects covered. Probate avoidance, which we're going to talk about, tax efficiency, even asset protection. So there's so much more when you start to dive into what estate planning actually is than what people think it is.
Okay. Great. Fantastic. And so with that, Kristen, what are some of the most common misconceptions that you see and hear when people first come to you to discuss estate planning?
Well, you kind of touched on it with the first question that you asked me was, do you have to be older or do you have to be super wealthy to need this type of planning? I would say that one of our larger client bases are clients that are on the younger end and they're starting families. So when you have
Okay.
children,
Mhm.
that is a major motivation for a lot of our clients to start getting estate planning because they want to make sure that if something happens to them, that their kids are taken care of. So with, trust planning, you can make sure you avoid probate, but then you're putting somebody that you really trust in charge of those assets for your kids. You're creating a plan for your financial wealth and how you're going to pass that on to your heirs. So I think that's, one of the most important things that a lot of our clients are thinking about. And I think one of those other misconceptions, like Lauren said, was that, they're going to have to pay tax. So explaining that super high minimum, maximum amount that you can have before you have to pay any type of taxes. And then I'm trying to think of something else that we hear all the time. Probably
I
that
think
if
a
you're
lot of
married, that you don't need estate planning. You're like, well, everything's just gonna go to my spouse. And I think
Sure.
if you don't have certain planning, some of those things may still get to your spouse, but maybe not in the way that you intend it. And it might have to go through that probate process that we're going to talk about a little bit later to be able to get to them. And that delay in time can be really detrimental to families.
Wow. Okay. And Lauren,
I
can
was
you
just
add
going
to
to
that?
say,
Yeah.
yeah, no, I was just going to say, I think just expanding, on what Kristen said, we have a lot of people that show up to consultations or through their design process that they have a big aha moment of what they actually have. Because oftentimes when we think about our wealth, we think about what we can access liquidity wise, right? So
Sure.
our cash, maybe our investments, but when they get the full picture, and if they have a great financial advisor, they're already going to be doing this, of course. But if they get
Like
the full
myself.
picture, like
Yes.
David here, like David,
Mhm.
you're going to be going over it with them. You're going to be explaining. They're going to have the full picture. But so many people, they really don't. And when they look at everything they have, their home, investment properties, their vacation homes, life insurance, it really is like a big light bulb moment of, wow, I'm worth a lot more than I thought I was. And it's, it helps us to set the frame the conversation around, okay, how do we now protect?
Sure. Okay. So let's talk a little bit more about wills and trusts and the basics I think that everyone should know. And 20 years ago, over 20 years ago, when I got involved in financial services and wealth management, I really didn't know too much in terms of the difference between wills and trust. So one of the biggest questions that I talk to my clients about regarding wills and trust is what exactly is the difference? Do I need a will? Do I need a trust? Do I need both? Can one of you break this down in a simple way where what is a will? What is a trust? And do people need that or not?
Lauren's our professor, so I'll let her take this one since this is what she teaches her students all the time.
All right, I'll put
Fantastic.
my professor hat on. So it really depends on the person's situation. So let's walk through a couple different common scenarios that we see that can help your listeners kind of get an idea of where they need to go. So, what does a will do? All that a will does is it says, here's who gets my assets, maybe spouse and then children, kind of the most common scenario. It just tells that probate court who the assets go to, but it does not, in and of itself, avoid the probate process that we're going to talk about.
Okay.
But it's something, it takes you out of the default. If we don't do anything in the state of Florida or any state in the United States, basically a set of default laws kicks in called intestacy. So if you pass away and you have no estate plan and you have no beneficiary designations like a payable on death or transfer on death, intestacy kicks in. So let's say I die with a house and I have a spouse and children, and all the children are joint children. Typically, intestacy says it goes to spouse and then it goes to children. But it might have to go through the probate process depending on how things are titled. So a will is actually fairly ineffective in and of itself, which a lot of people just don't realize. So that's kind of a big thing for people to take away right now. A will just tells the probate judge who gets your assets.
Sort of like an instruction.
Now,
like
it's
an
instruction.
Hey,
right.
Judge, this is what I would like to have done. If I pass or when I pass, what do these assets, how I would like to have it be distributed? It's just an instruction. Okay.
Exactly. But when that's the only instruction, it's pretty inefficient because it still has to go through that probate court process.
Okay.
Now, that doesn't mean that every single person on this planet needs a trust. Sometimes if we have someone that comes in, let's say the most common scenario is an older individual or maybe an older couple. All of their children are, well into adulthood. They're not really concerned about their children getting divorced and protecting with a trust. Their children aren't, high liability professions. And maybe they don't have a ton of assets. Maybe they come in and they're like, okay, I have a condo on the beach. I have a bank account and I have a brokerage account. Do I need a trust? They may not. They may be able to avoid probate with working with David to make sure that all of your accounts have your beneficiaries named. You can avoid probate by having beneficiary designations on bank accounts, brokerage accounts, retirement plans, life insurance, et cetera, et cetera. That often gets missed, that step. So that's important. You can avoid probate in the state of Florida on real estate. Obviously, facts and circumstances, but with an enhanced life estate deed, sometimes called a ladybird deed. Not all states have this, but in Florida, we are very lucky to have it. It's a probate avoidance mechanism. So maybe you're able to do all of the planning you need without the trust. But that's a very small subset of our population. Most of our clients are coming in, they have either minor children or maybe their children are in their 20s, 30s, 40s, and they are like, well, I don't want them to get all of these assets outright. A trust probably makes sense. Maybe they have business interests that they want to pass on and they want to have a contingency plan and a succession plan. A trust probably makes sense. Maybe they want to give their children kind of a little mini prenup and keep those assets tightly in a trust bucket. Again, they probably need a trust. So I would say maybe 10 to 15% of the folks that come into our office, we can probably get away without a trust. And we'll always explain both options, but most people will need some sort of trust, typically a revocable trust. Very simple. You can put assets in, take assets out. You can change it. It's cost effective, but it's very beneficial.
Okay. Kristen, any add-ons to that?
Yeah. One thing I want to note is that if you have a trust, you're going to have a will as well. The will is still important. It still names who your personal representative will be if you need to have a probate. Let's say you don't title everything in the name of your trust and something is missed. You still want to make sure that you have that will. But another thing that the will does that is really important for a lot of people is if you have minor children, it's naming who the guardians of your minor children are going to be. So, sometimes a will is only fact specific if it's your only document for certain individuals with less assets, but everybody that has a trust is also going to have that will. It's just called a pour over will. So what it does is it kind of just grabs everything that would need to go through probate and it puts it into your trust that you created.
Okay, fantastic. So this can go to either of you or both of you. What are the key documents that every person should have in place, regardless of their net worth?
Want to take it?
Yeah, I'll take it. These are what we call our ancillary documents, and really just anybody over 18 should have them. And Lauren touched on them a little bit earlier. It's going to be your power of attorney. That's the document that says who can make legal and financial decisions on your behalf. In Florida, it's durable, so it can be used whether you have capacity or not. So if I name Lauren as my power of attorney and I'm just not available, she can, sign checks on my behalf or deal with other types of financial issues. Or if I'm selling a property or something, she could sign on behalf of me. She's really stepping into my shoes while I'm not available or if I'm incapacitated. So that's a super important one. And it's one that I think a lot of people have heard of. The next one that's super important is the healthcare surrogate. And that's a document
Sure.
that if I'm not able to consent to some sort of medical procedure, let's say I'm incapacitated or I'm in surgery, I am naming somebody that can make those decisions for me. Sometimes if you're married, your spouse is able to do that and you kind of sign that paperwork with the hospital. But, if you're in a situation where that's not the case, or you just want that extra paperwork to make sure that they know that this is the person that you want to make those decisions, super important because we never know when we're going to need that. That's not necessarily age
Sure.
specific. One of the next documents that's super important is the living will. And Lauren and I grew up during the age, and I don't know if you remember this, David, with Terry Schiavo, where
Yes.
she was on life support. The husband was
Yes.
saying that was not something that she would have wanted. Parents, they really wanted to prolong her life because how horrible to have to make that type of decision. And there was a lot of court, it was a Florida issue. So there was
Yes.
a lot of coverage on that. So in our document, you're saying what your wishes are, you're memorializing them, and you are saying who you want to carry forward those wishes. So I think it takes the burden off of family members and makes it super clear what you want to happen in that type of circumstance. And then our next one is pre-need guardian. This one is a little bit more fact specific, but you're saying that if you need a guardian named for you as an adult, because we think of guardians for children, but not always for adult individuals. But sometimes that happens, whether it's a capacity issue, whether it's temporary or more long term due to something like dementia or some other issue. You're saying who you would want to take care of you personally and who would take over kind of your finances in that instance. So those are a few documents that just really everyone should have because you just do not know when you'll need them realistically.
Okay.
And then on
Lauren?
top of that, you're usually choosing, in addition, do I just need a will or do I need a will and trust? So that's kind of like the
Mhm.
dispositive document we call, like who gets the assets. And then the
Yeah.
ancillary documents are while you're living, who makes decisions and things of that nature.
I want to go back to Kristen, who just a little while ago mentioned about trustee and power of attorney.
Hmm.
Are they both the same party, or can they be both the same party, or does it have to be
Yeah.
separate when it comes to someone who is a trustee of that trust versus the power of attorney? Can you elaborate more on that? Because I have
Yeah.
gotten questions like this in the past, and
Yeah.
let's provide clarity right here, right now.
For sure. So the power of attorney is a totally separate document. So if you want it to be the same person, and a lot of our clients do pick the same individual, they'll say, I trust this person to handle my trust assets. I also want them to handle kind of my finances and other aspects, but they don't have to be. So sometimes they're the same, sometimes they're not, but they're totally separate documents and they have kind of separate purposes.
Mhm.
Your trustee is the person, oftentimes the grantor is their initial trustee. The grantor is the person who creates their trust. And a lot of times they're the first trustee of their trust. But, you can name somebody else. If somebody else is acting as trustee, they are managing the assets that you have titled in the name of your trust. So if you have a bank account that is
Okay.
not in the name of your trust, then your trustee doesn't have any control over those assets, but your power of attorney can because they are in
Aha.
your individual name. So that's kind of the differences between the two, but oftentimes people have named both. The other thing I want to mention,
Mhm.
because this is a misconception that we see all the time, so I want to make sure to get this out there to anybody that's listening. The power of attorney is only active while you are alive. So if you pass away, that power of attorney it's extinguished. And so I have a lot of
I
clients that'll
see.
say, "Oh, I'm going to transfer the property of my mom. She named me power of attorney before she died." That power of attorney is no longer going to help you. So that's something I also wanted to note.
Okay. Lauren, anything to add?
I mean, I think just to drive home that last point, because I think it is an important one, we do get a lot of calls when someone has passed and there was no estate planning done or it wasn't adequate because
Mhm.
we often see, unfortunately, that someone has an estate plan, but the assets weren't retitled, meaning, maybe they move a brokerage account into the trust or they name the trust as a beneficiary. It really depends on the type of asset and how the estate plan is set up, but it has to happen one way or the other. The assets need to be retitled. They need to be aligned with the estate plan because, Kristen's giving an example that she heard all the time, especially when she was at a big trust company. And people think that they are covered and they're not. And then they get very frustrated because now they have to spend a lot of money and go through a lot of court stuff.
Sure.
So I think that's one of the biggest
Probate.
things, actually retitling the assets and realizing, again, that power of attorney, it dies with the principal, the person who creates it.
Great. And as we're on this subject of trusts and trustees, people have asked, should I name a trustee a family member, a good friend, good friend as in, friends for decades, or hire someone commercially to be the trustee so that so it's a third party without any family or personal relationship influence. How do you guys answer that? How do you ladies answer that?
I'll kind of take the first end of this, and Lauren, you can fill in any blanks, but this is so fact specific with our clients. We want to understand about their family. So we talk to them a little bit about, their family dynamic. Is it a blended family? This is a big determination of who you're going to name as the trustee, because if you have a spouse, oftentimes individuals are naming their spouse. But if you have children from another marriage and that spouse is going to be then kind of in charge of holding the purse strings for their stepchildren, that may not be a good choice. So maybe a corporate trustee, somebody that's totally removed, that does this for a living, and they don't have any personal stakes, may be a good option. I think deciding whether you want a corporate or separate trustee to act also has a lot to do with what type of assets, because a lot of trust companies have minimums that you have to reach before they're able to kind of accept that trustee designation. So you might have to have maybe a couple $1 million for that to make sense, unless you can find another third party like a law firm or somebody else that offers those services. So those are some of the things that we think about. But we always want to make sure, would you trust this individual with your money? Do you think that they get along with who the beneficiaries are? Is that going to make sense? Sometimes we have clients that say, oh, maybe I want to name one of my children to be trustee of the other child because that child's not as good with money and they're a little irresponsible. And we kind of dig into that a little bit more. Does that make sense? Is that going to cause an issue between the beneficiaries? If a sibling has control over another sibling, is that going to create animosity? So I think just getting to know our clients, if we're working with a financial advisor like you, we're asking you more because you work with these people every day. You almost become part of their family. So it's super important to kind of understand that dynamic and see who's going to be the best individual. But there's no specific rules of you can't name your friend or you can't name someone in particular that you think fits the role.
Okay, so you don't have per se a rule of thumb or just a default to recommend personal family members, spouse versus a trustee that is for hire.
Not necessarily. I think
Okay.
it's just really talking with the client and seeing what does their estate look like? What's the value and what's the family dynamic or the dynamic between the individuals that they're thinking about naming? If somebody comes to us and they say, I have a $10 million trust and I want to name my 20-year-old beneficiary to be the trustee, we might say, hey, does that make sense to give them that much control? And are they going to be able to stretch out those assets for the intended amount of time? So I think just having that conversation really helps solidify what the right answer will be. And at the end of the day, it's their money, it's their trust. They're going to know best, but we try to give them guidance based on our experience.
Fantastic. Lauren, from a legal and tax standpoint, what complications can arise from families in a situation where someone passes, or I should say, the major owner of the asset passes away without an estate plan? What happened?
So, if we talk about very wealthy clients, high net worth or ultra high net worth, meaning if it's an individual, they have more than 15 million. If it's a married couple, more than 30 million, which there are still many Americans with that wealth level. And we have many
Sure.
clients at that wealth level. You're basically looking at estate tax inefficiency. So anything, there's a sliding scale, but we'll just say 40%. Anything above the exemption, you're going to have a 40% estate tax at the highest level, which is obviously a very big
Huge.
piece of the wealth. I mean, that can really make or break a family's, whether they stay wealthy or not. So a lot of wealthy families will set up dynasty trusts and move assets into these trusts, and they remain exempt from estate tax forever. So that's something to think about for the very wealthy. And then for the rest of Americans, you still may want a similar dynasty trust because we don't know what the estate tax exemption is going to be. When my parents set up their estate plan, I think it was 500,000 or a million. So they had a taxable estate. Now they're nowhere near it, but that just goes to show with even a couple of decades, tax laws can change dramatically and there's uncertainty. We don't know what's going to happen. So we'll advise clients on, okay, here's what we know now based on your wealth level, but we don't know what's going to happen in the future. A lot of our clients are in their 30s and 40s. Maybe they have a $5 million estate right now, but if we're working with a great financial advisor like you, David, we're going to work together to show them the forecasting of, okay, but look at what your wealth will be in 10 years, 20 years, 30 years. It's very likely that you will have a taxable estate
Sure.
without even knowing what the exemption is going to be. And so we'll plan with a very forward thinking. But even putting all of that aside, one of the biggest tax issues that we see is how assets are titled during life from an income tax perspective. So we have a lot of clients that will come in and they'll be like, oh, I added my daughter, my son to my house because my spouse had passed away and I want to avoid probate. And we'll walk them through what does that actually mean? You might be creating an income tax inefficiency. The Internal Revenue Code has this pretty neat law that says if I inherit assets from someone that passed away that owned those assets in their individual name or through a revocable trust, there's a step up in basis. So what does that mean? If my mom bought a house for $100,000 in Fort Lauderdale and when she passes it's worth $1 million, let's say there's 900,000 of appreciation in there without improvements or anything like that. If I inherit that home, I get a new tax basis of $1 million equal to the date of death value. So if I sell it the next day, there's no income tax effect. If she adds me to the deed, she's actually giving me a gift, which gives me a transferred basis, meaning I would get her $100,000 basis on the half that she gifted. So I'm creating an extreme income tax inefficiency. So what we're doing for clients is we're looking at what assets they have, how they're titled, and what that means going forward. Another thing that we look at is keeping assets in trust, which I touched on a little bit earlier. So again, keeping assets in trust for especially children and grandchildren can be very beneficial because no matter what those assets are worth in the future, no matter what that estate tax exemption is, they are now protected forever from estate tax. They're also protected from creditors of the beneficiaries if the trust is structured properly and the assets stay in trust. And again, like I said before, it's like a little mini prenup. So if that child gets married and they don't pick well, or just, life happens, they get divorced, those assets don't automatically become marital assets. So many benefits, tax and non-tax.
Fantastic. My next question, I want to have just a little prelude to the question, which is several years ago, I had he was an airline captain who I have worked very closely with. We were in the midst of putting together his estate plan. He was single when he died very unexpectedly. He had just gotten divorced about a year prior. He had adopted the young son who was 5 or 6 years old at the time during the marriage and then subsequently gotten divorced. And then he died very unexpectedly, again, while we were in the middle of planning his estate planning, legacy planning. And we went through a very rigorous and very difficult probate because subsequently the ex-spouse actually contested many things. And so here you are, it's a complex scenario. And that was my first time going through this type of an ordeal, which as an advisor, it was very difficult because I was getting pulled from many different sides, from the probate court, from the attorney that represented the ex-spouse, that she said that these assets subsequently belongs to her because they were planning on getting together. And then, of course, subsequently, because he had legally adopted a very young son, there was the rule of law where it gets passed down to him. And so there was a lot of things that took place. And this is one of the many reasons that I'm so happy that both of you are here, because I'm able to share my real life experience as a financial advisor to share with the experiences that I've had. So, if we can, perhaps, Kristen, how does probate work? Most people don't know because they've never been through it.
Yeah.
And
Right.
why do so many families need to try to avoid it? And
Yeah.
I tell my story amongst other stories, but this was one that was very clear to my mind, is very highlighted because it was my first, and subsequently it was a very difficult probate process. So,
Yeah.
Kristen?
Thank you. I think the first part is to figure out, why do you get to probate in the first place? So you end up
Okay.
in probate when you own something in your individual name and you pass away and you have not named a specific beneficiary on that account. So there are ways, whether it's a transfer on death or a payable on death type of form that you fill out when you open up that account, or an IRA, a beneficiary designation form. If you fill that out and you have named beneficiaries, oftentimes that will avoid the probate process. But if you have not done that, which a lot of banks and institutions don't always prompt you to do that. I think IRA accounts are really good about it. And if you have a good advisor, they'll make sure to do it. But on your general bank account, when you open up your accounts, they're not asking you, who do you want your beneficiary to be? So if you don't know that you need to do that, that account likely could go through probate if you own it by yourself. So
Mhm.
let's just say you haven't done any of that planning and you have all of your accounts in your individual name, like I do. I'm not a married individual. Then everything I own will have to go through probate to get to who it will get to. If I have no will, like we said earlier, and I haven't decided who my assets go to, the state of Florida decides who those assets will go to. So, it's going to go to parents and then siblings, and, kind of goes off of who's alive at the time based on Florida law. If let's say I've done a will, then I get to decide who it is. So that's super important, because it might be really important to me that maybe I want to give all of my assets to Lauren's children. And Florida law is not going to do that by default. So if you know who you want your assets to go to, it's really important that you memorialize that. Otherwise, you're going to go with the no plan, the default plan of what the state decides. So that's the first thing about why it's going to be super important to have that planning in the first place. But then you have to go through probate. So you have to hire an attorney. That attorney has to, ask you a bunch of questions and file the initial pleadings to say, okay, who's going to be the personal representative? If you've named one in the will, then likely that person will be named. And they're going to appoint that person to be able to go and collect those assets, put them into an estate account, and then distribute them out to the beneficiaries. You have to pay for the attorney's time, which can be expensive. Sometimes they charge on either an hourly rate or a percentage of the estate assets, which can be anywhere between, 3 and 7%. So that can add up quickly. Or even at an hourly rate, I think that's why us lawyers get a bad name, is, when people get bills for attorneys, they don't love having to pay that. And if there are disputes like what you said, then that drags it out even longer. So those individuals that were to get those assets, it's going to take longer for them to get access to it. And let's say you do have somebody that really needs those assets to be able to continue paying for a home. Maybe a home could fall into foreclosure if nobody's paying, the payment on the mortgage. So there's so many things that can really draw that process out. But typically a probate, even at the best, will take a year. Sometimes it can take 2 or 3 years, depending on what type of assets are, how many beneficiaries, is everybody getting along, or is there any litigation involved? So, if you can create a trust, you avoid that probate process altogether, as long as you've titled everything in the name of your trust. But if you don't, then you're dealing with potential disputes and all the costs that go with having a judge making sure that those assets get where they're supposed to.
Any add-ons to that, Lauren?
I would, just to put it in a nice little bow for everyone that's listening, there's really primary ways that you avoid probate that Kristen touched on. One, you name a beneficiary, transfer on death, payable on death, beneficiary designation, whatever it might be, on bank accounts, real estate, IRAs, et cetera, et cetera. Two, you move it into a trust. Typically, that's going to be a revocable or revocable trust, very easy, very flexible. Sometimes it's an irrevocable trust. That's typically when we're talking about high net worth clients or clients with significant asset protection needs. But regardless, if assets are properly moved into a trust or the trust is named as on a beneficiary designation, that's an option too. That avoids probate as well. And the third is rights of survivorship. So let's say my husband and I own a home together and one of us passes away, it's going to pass by operation of law to the surviving spouse. The issue with that third way type is sometimes the surviving spouse doesn't then do what they need to do, like move an asset into a trust. So you want to have contingency plans for no matter what happens. But those are the three ways you avoid probate. If you don't do those three, either of those three things or any of those three things, probate happens. And the reality is, I think the statistics say, depending on which stats you look at, like 30% of Americans have an estate plan. But what we see amongst all levels of wealth is probably less than 10% of clients have an effective estate plan, good documents, and proper titling. So it's a very small amount. So probates, especially with this great wealth transfer that has already begun, probates are going to become very prevalent, which is we'll be busy forever, but we don't want people to go through that. It's often very easy to avoid. So talking about this stuff, I think is so important. So people know, because you don't learn this in school. You're not talking about it at the family dinner table typically.
And so with this in mind, there are people who doesn't necessarily know that when you go through a Florida probate process, that there is a cost to it. Many people, they understand that if they don't have a will, don't have a trust, a combination of both or either, that they know that their assets are going to be passed down to the structure of the Florida law. They don't necessarily understand that there's actually a cost to it, because while they're alive, they think that I don't want to spend this money because the state of Florida will follow through and it will go to my kids or go to my surviving spouse. So I don't need to spend the money while I'm alive. Can you give a little idea to the viewers and the listeners as to the approximate cost that they will incur in their estate if they don't have something like this? And ultimately, I believe it's shrinkage of their legacy that ultimately gets passed down to the people that they want the assets to pass down. So is it cheaper to have an estate plan or and spend a little money on that, or subsequently let the probate take its course?
Yeah, I mean, if you're looking at it like trying to look at it from apples to apples, it's a little tough. A good trust estate plan will probably run you starting around 4,500, $5,000. If you're working with a good law firm that will take the time to do a really good job and make sure your plan works. A probate is probably going to start at around the same price. So you might think, well, great, I'll pass that cost on to my family. But you have to zoom back for a second. You have to think about, one, that's on the low end. So typically a probate can get much more expensive, especially if there's businesses and there's real estate and there's disagreements. But let's just say it's pretty straightforward. You still have, one, it's going to take at least a year or not, if not longer. Who's going to be paying the bills in the meantime? Who's going to be taking care of all of that? What is the opportunity cost of those funds sitting in the probate court, becoming public information? It's a very administrative process that you've now passed on to your family who are grieving, and now they have to deal with all of this. So apples to apples, maybe it's similar. In a very good case scenario, most likely the probate on its face will be more expensive, but it's also all of the other stuff that comes along with it. The time loss, the administrative, the inefficiencies, and just the opportunity cost of not having a chance to work through, how do we make this efficient? How do we get assets to people in the right way? Because you might say, oh, it goes to my kids. But what if your kids are 15? They're not adults. They're minors. They can't legally inherit those assets. Now, guardianship proceedings also have to be open. That's going to cost another, who knows how much, thousands of dollars. Now they're going to get all of those assets at age 18. That's very problematic. I don't know what you would have done with a lot of money at 18, but I would have not done good things with it. I would have blown it. There's also no guardrails. So maybe you have a real estate portfolio. Now all of your children own it together. What if one wants to keep it, one wants to sell it, one wants to live in it? That's litigation in and of itself. So when you really start to zoom out of what the cost of a lack of planning is, it is significant. And when we see probates, all our brain does is, oh my gosh, if they had just done this and this for whatever cost, call it $5,000, $6,000, it would have saved so much money, time, heartache, litigation, fighting, families potentially torn apart. I mean, we see it every day, and planning is really, estate planning, it's an extension of your financial plan. We're all working hard. We're building careers. We're building businesses. We're taking care of our families. If you miss this piece, unfortunately, it can be disastrous, truly.
Wow. Kristen, anything to add to that?
Yeah, I was going to say on the lower end, like Lauren said, those are going to be the super easy probates too.
Yes.
If you have more complex assets, that's probably somebody has a house and maybe a couple bank accounts. Super easy.
Okay.
If it gets more complicated than that, if you have a business, if you have more assets that are going to need more care, then it's going to be more than that, just at the bare minimum. Just to file it with the court is between $400 and $500. So that's just an administration cost that's kind of going to nothing. So yeah, I would say, and the biggest part too is you want to make sure that it's clear who's going to get your items and that it's fair. I mean, you can have a lot of fighting over things you don't expect. Lauren had a case where people were fighting over a vacuum cleaner. They wanted to fight over who got the Dyson. And do you really want that to play out in court? And 1 hour of an attorney's time fighting over the Dyson is going to pay for another Dyson very quickly. So you just want to make sure that when people have emotions, and that's when that attorney's fees, you kind of see that with like class action lawsuits, and you're like, oh, I got this notification in the mail that I'm part of this lawsuit. And then you realize, oh, the only person that won was the attorney in this instance. I'm getting $7 for this settlement. So we want to make sure that clients aren't getting put in a similar circumstance where all of those funds that your parents or your family member or your friends or whoever has named you has worked for isn't going to pay for attorney's costs. And I probably shouldn't be saying that as an attorney, but that's our goal, is to make sure that money isn't being wasted and it's going to who you intend it to be.
Fantastic.
And I want to add a couple things, if I may, David.
Sure.
One, we're just talking about Florida probate. So we have probates right now where there's assets in other states and other countries. That means a probate is needed in each of those jurisdictions. So 5 times, I think it's going to be probably the one I'm thinking of. It's gonna be like 10 grand here. It's going to be like 4 grand in the other state. And then there's international assets too. So that one is going to become very, very expensive. Wow. Another thing I want to add, I think we said this, but just to drive it home, in Florida, an attorney is required to open a probate in most instances. So it's not like you can opt to go pro se and represent yourself. You cannot typically. So that's also something to be mindful of as well.
So people often overlook incapacity. They think, okay, if I pass, what will happen? But not many people consider the next to the worst, incapacity, and also long-term care for the elderly. Nobody wants to go into a nursing home or in a assisted living facility, but that happens. Last time I checked, stat-wise in the state of Florida, there is a waiting list of people going into the good facilities. So how does the full effect of comprehensive estate planning play into incapacity and long-term care planning? Either of you.
I think thank you, Kristen. From an incapacity perspective, that could really be at any age. And so we tell our clients, look, a lot of this planning is we're hoping you have a long, healthy life. You pass away at 105 peacefully in your sleep on a beautiful Mediterranean vacation. Like, that's what we all hope. And this planning will work for that. But things happen, accidents happen, things go awry. We were talking with a person at a trust company that we work with a lot, and she said one of her clients is a husband and a wife the wife is incapacitated, but she was very young, and the husband was struggling trying to run a business and take care of children. And so having a trustee step in and manage a lot of that is really important. So
Mhm.
the documents, estate planning documents, can help dictate what's going to happen in an incapacity instance, whether it's who's going to make decisions or who's going to manage the trust and things like that. When you start to get into things like nursing home and Medicaid and things like kind of a subset of estate planning, it's called elder law or special needs planning even sometimes. And that is a different type of conversation about what are your assets and what is your income? And are
Mhm.
you potentially going to be able to qualify for government benefits? And how can we
Mm.
do some planning to make sure that you can qualify? So there's some clients that are so wealthy, it probably ethically doesn't make sense, but two, they would never be able to get rid of enough assets to qualify, nor would they probably want to. But for a lot of families, maybe they have 1 million or 500,000 and they're like, wow, with the cost of nursing homes or in-home health care, like I'm going to lose all my money and my family's going to have nothing of the hard, earned legacy that I worked for. And so Medicaid can step in and Medicaid planning can step in to remove
Mm.
assets and reduce income legally to make
Mhm.
sure that they are able to apply for Medicaid and not run through very quickly all of the funds that they have.
And
So
does your
yeah,
service, does the Flourish Law Firm help with that type of
we do.
planning? Okay.
We do. We do.
Anything else
Yes.
to add, Kristen, on what Lauren did?
I just wanted to say, because there's super low minimums about the amount of assets that you can have to be able to qualify. But one of the
Right.
things that a lot of clients ask us, and I just want to note this, is, they worry about whether they'll have to sell their home to be able to qualify for Medicaid. And one
Mhm.
of the neat things that we have is your homestead is actually protected. So as long as you keep your homestead while you're in a facility, that asset doesn't need to be liquidated to be able to qualify for the minimum amount of assets. So
Okay.
I think it's one of the top questions that we get.
Great. And what do you find most rewarding about helping clients through these important life decisions for you, Kristen?
I think that for me, it's just watching kind of that weight go off their shoulders. We have a lot of
Mm.
clients that say, I've been putting this off and been thinking about
Yeah.
this for a long time. I'm so embarrassed. And we're like, you're already sitting in the chair.
Right.
This is already a win that we're starting this conversation. So I think that once, especially, people that have younger children, I think that's something that really weighs on them that, oh gosh, if something happens to me, who would take care of my kids? Who would take care of my assets for my children? So I just think that kind of that satisfaction of knowing that they've done all that they can and they've been responsible and they've tried to set up their family members in the best way possible. I think it helps people sleep better at night, knowing that they've done that planning.
Great. And do you offer, Flourish Law Group, do you offer a complimentary discussion, a
Yes,
meeting? And okay, so it's
we sure
complimentary.
do.
Of course, you'll, of course, talk about fees. That
Hmm.
is probably customized to each particular client and each particular individual
Absolutely.
based on their scenario. Where can listeners connect with you and learn more about Flourish Law Group?
Well, we have our website and you can schedule a meeting with us there. Our
Okay.
initial consult is called a legacy planning session. It's 30 minutes long, and that's where we get to know you. We talk to you about your family, about your assets, about prior documents that you may have, and we'll even look over those documents to see if, what our recommendations would be. So I think it's a great low barrier to entry that you can have a
Sure.
conversation and just see if, we're the right fit because, everybody has to pick who they want to work with. And we like that to be an opportunity so they can see, are they comfortable with us? What have we brought up? It aligns with what their concerns are, and then move forward if they're ready to take those next steps. So our website has the link. We can
Mhm.
provide you a link if
Yep.
you want to give that to the clients as well.
Yeah. So if you could provide us what the website is, and then Kristen, if they want to directly contact you, what's a good email address for you? If you could please just tell us that.
Sure. Our website is flourishlawgroup.com, and my email is chrislandon@flourishlawgroup.com, and Lauren's is Lauren Klein at Flourish Law Group.
Fantastic. And for those viewers, it will be on your screen. And for those listeners, it will be at the bottom of the show note of this podcast. Any final words?
I just want to add to that we are only licensed in the state of Florida,
Okay.
but we do work with clients that have, maybe they live in New York and they have Florida real estate. But if there's someone who's listening who's like, well, I'm in Ohio, how does this help me? You can always shoot one of us an email. We have been collecting a wonderful group of attorneys across the country. So we
Great.
would be happy to help whoever's listening and get them connected with someone that could be a good fit for them.
Referral or reference partners, resource partners, that's fantastic. Fantastic. If today's conversation helped you think differently about your financial plan, share this episode with someone you care about, because wealth isn't just about accumulation, it is also about coordination. At DTY Wealth Planning Solutions, we believe your financial strategy should be integrated. Investment planning, tax mitigation, structure, and legacy design all working together collaboratively. If you'd like to learn more about building a comprehensive wealth plan, please visit us at DTY Wealth Planning Solutions or connect with us directly on the information in the show notes. And if you enjoyed today's episode, please make sure to subscribe, leave a review, and join us next time on Jet Setting Wealth Advisory, where we can help you build wealth with purpose and plan your financial future with precision. Until next time, stay strategic, stay intentional, and we'll see you on the next flight. Thank you and goodbye.
Thank you for flying with us on today's episode of Jet Setting Wealth Advisory. If you enjoyed your journey through the fiscal skies with David T.U., don't forget to subscribe to our podcast and keep your financial knowledge soaring. For more insights and personalized advice, visit us at www.dtywealthplanningsolutions.com and connect with David directly